Good afternoon, everyone. Welcome to this Global Friction seminar. Thank you for coming. My name is Kerry Mullen. I'm Convener of Languages here at RMIT and also Deputy Director of the Centre for Global Research. It gives me great pleasure today to introduce my colleague, Dr. Georgina Heydon, who is not only Director of the Centre for Global Research but also a Senior Lecturer here in Justice and Legal Studies. She's also President of the International Association of Forensic Linguistics, and she is a colleague and fellow linguist, and she will be bringing all of that together very shortly as she talks to us about widespread misconceptions about language and how they cause systemic failures in the justice system. Please join me in welcoming Georgina to the stand.
Thank you, Kerry. Before I begin tonight, I wish to acknowledge the Aboriginal custodians of the land on which we meet. And we meet here so aptly, because indeed this place has hosted meetings of the Wurundjeri and the Bunurong people for thousands of years. And given our subject matter today, I find it apposite to consider for a moment the perspectives of those Aboriginal people who, within only a few years of white invasion, saw 5 of their own people make up the first 9 executions in Victoria at the old Melbourne jail, just behind us. Sadly, the legacy of those brutal times has not left us, and the overrepresentation of Aboriginal people in the justice system has continued unabated, a situation which is exacerbated by ignorance of many kinds, linguistic and otherwise. I'm going to start by reading from something I wrote not long ago when I had the pleasure of reviewing the excellent book, Discursive Constructions of Consent in the Legal Process, edited by Susan Ehrlich, Diana Eads and Janet Ainsworth. By way of introduction to the review, I wrote that as Secretary of the International Association of Forensic Linguists from 2011 to 2015, I would receive about once a week an email that went something like this. Hello, I am studying English literature, and I really enjoy seeing how language is used by people. I'm also very interested in crime investigations, like in CSI. Please, can you tell me how to become a forensic linguist? Cursing that I still hadn't got around to writing a form letter to send back on such occasions, I would set about trying to answer the question and offer some guidance to the student, but almost immediately I would find myself in a quagmire of vague definitions and overlapping categories of linguistics, legal applications of language analysis, and qualifications required to work in the field. I began to suspect that a clear description of forensic linguistics was impossible, and even the commonly understood dichotomy between forensic linguistics as expert testimony and forensic linguistics as research into language and the law seemed misleading. The reason I want to mention this now, apart from having the opportunity to draw attention to a book which I think goes a long way towards addressing some of the issues that I'm going to speak about today, is that it highlights a problem with the way that forensic linguists conceive of ourselves, both as individual researchers or practitioners and as an international body. Quite frankly, we are really bad at self-promotion. And the grossly ill-informed emails I would receive as Secretary of the IAFL are a testament to that failure of a clear public identity. So, given that lack of public recognition, I'm going to conduct an experiment. You didn't know you were getting in for that, did you? No, I don't have consent forms. Okay, so I want you to listen to the opening verse and chorus of Jonathan Richman's Girlfriend, and I want you to tell me what you think is the most salient linguistic feature of that song. So, now listen carefully. Okay, thank you, Mr. Richmond. We'll edit that out of the video version, aren't we? Copyright. Okay, so what was the most interesting linguistic feature of this song? Was it A, Jonathan Richmond incorrectly spells girlfriend? Well, you guys are either primary school teachers or you've just emerged from 2 weeks of marking undergrad papers and are obsessed with spelling and grammar. I get that, but it's not linguistics. Okay, so what about B? The song starts with the rare English conditional subjunctive, if I were. You're language teachers, aren't you? You're probably French, Kerry Mullen. I'm looking at you. I'm a big fan of the subjunctive, but again, that's not really a linguistic observation. So, C, in the accepted folk tradition, Mr. Richmond disguises the fact that the first line doesn't have enough syllables by singing Boston with 3 syllables. Yay, some poets in the audience. You know a dodgy metre when you hear one. Super, but not linguistics. Or D, Jonathan Richmond doesn't misspell girlfriend, but rather has opted for the creative solution of using a partially phonemic rendition of the last 4 letters, E-end. Also, the nasalisation on all the backgrounded vowels suggest he had a head cold at the time of the recording, especially if we compare this to later recordings. Also, it's non-target, not incorrect. Yes, there are the linguists right there. Or let's take another example. When you hear someone say, "So who are you versing at netball on Saturday?" what do you think? Or in the immortal phrase that my mum heard in the late 1950s, fresh off the boat from England at a cafe in Perth, "Have yous had yous puddings took?" Because to a linguist, these are just such interesting examples of language innovation, I feel quite dizzy with excitement. But nonetheless, to any forensic linguists in the audience, I ask you, how many conversations have you had recently in which you tried to explain what the IAFL is, what a forensic linguist does, and then inevitably what linguistics is? Since I work in a criminology department in a broad social sciences school with no linguistic specialisation, I have these conversations almost daily. And that's just with my colleagues. Then there's friends, family, taxi drivers, a woman running a hotel in Sussex, some person in the insurance agency. Every time I mention my research, even in passing, I have to launch into an explanation about the analysis of language, how I'm not a speaker of many languages. I heard a great thing, which was the plural of anecdote is not data. And I think the plural of language is not linguistics. And the fact that nobody seems to care that it's possible to analyse language systematically in this age of texting and messaging and blogging and emails, the bottomless pit of emails. I'm seriously considering getting authorship attribution. It's not like handwriting analysis printed on a T-shirt, but then I'd only have to explain the T-shirt. Other contenders, by the way, are no, I don't care that you split an infinitive. It's a word if people know what it means. And obviously, no, it doesn't mean I speak a lot of languages. I think you see my point. No one knows what we do and no one seems to care that linguistics is, as they say, a thing. And this lack of public knowledge and recognition might be amusing and not a unique problem. I'm sure that taxidermists spend their Christmas dinners saying, "No, Auntie Flo, I don't drive a cab." Except that it has some very serious consequences. When people are not even aware that our field exists, that a professional or expert opinion is available and appropriate, some appalling decisions are made in the justice system that cause irreversible damage to those affected. Today I'm going to discuss the kinds of miscarriages of justice that can occur when decision makers do not have sufficient linguistic knowledge to know what they don't know, and the impact on justice processes of widespread public ignorance about language. We'll begin by examining a set of case studies that represent the range of decision types and justice contexts that are most affected by this knowledge gap. We'll then explore the opportunities for addressing these gaps through linguistic research and training. Finally, we'll consider a set of recommendations for how we can raise awareness about linguistics and reduce ignorance and bias that relate to language use. The first case is that of Jean Gibson, which some of you will be familiar with. And while there were several aspects of concern in this case, I'll focus on the failure to engage an interpreter. In my opinion, that's probably the most common cause of a linguistically related miscarriage of justice. Now, in presenting the facts of the Gibson case, I'm drawing on the work of my PhD candidate, Joe McFarlane, who's at the back there, thank you, Joe, who's making an important contribution through his study of miscarriages of justice and multilingualism in Australian legal procedures. I wish to acknowledge that parts of this case description are his work, not mine. The case against Jean Gibson began on February 28, 2010, when the body of 21-year-old Broome resident Josh Warneke was discovered by a local taxi driver on the side of Old Broome Road, Western Australia. The autopsy found that Warneke had died as a result of severe head injuries combined with acute alcohol intoxication. And he'd suffered a fractured skull, lacerations to the skin, bruising, and had acquired a brain injury. After local Broome police had initially investigated, officers from West Australia's Major Crime Squad took over the investigation into his death. The investigation was titled Operation Evermore and initially lasted over 2 years. During this time, Jean Gibson was identified as a person of interest. An initial unrecorded witness interview lasted nearly 3 hours, during which Gibson made admissions indicating that he had struck Warneke with a vehicle. He was then formally arrested and took part in a recorded interview, which was conducted by the same officers who had interviewed him as a witness. This interview lasted almost 6 hours. During neither the unrecorded or recorded interview did Gibson have an interpreter present. Despite English being his third language, his first was Pintupi, and he used this language to converse with Simon Butler, a senior member of the Kirikora community who police had called in to assist with the interview. Crucially, Gibson was capable of using some English, enough to sustain a rudimentary conversation, leading interviewing officers to believe that he would be able to participate in an interview without the assistance of an interpreter. A second recorded interview was conducted the next day in Broome. The officers who had initially interviewed Gibson offered an account to the Chief Supervising Officer about how the first interview had been conducted. In order to eliminate any perceived flaws in the process, the second interview was requested. Local detectives from the Kimberley region who were not involved with the Major Crime Squad were at this time assisting in additional inquiries. A senior sergeant who was in charge of the local Broome detectives suggested to members of the Major Crime Squad that an interpreter be employed for the second interview. This suggestion was not acted upon due to the belief of the interviewing officers and their supervisor that one was unnecessary. This meant that Gibson was not given access to an interpreter during any of his unrecorded or recorded interviews. During a pre-trial hearing, Gibson's interviews would be ruled inadmissible, given that at no stage had he been properly informed of his rights as a suspect, meaning the admissions he made were not voluntary. It became apparent that during the unrecorded interview, Gibson was only informed of his rights as a witness. Linguistic evidence called by Gibson's counsel found that his lack of understanding of English and the absence of a suitably qualified interpreter meant that Gibson had never understood his right to silence and was in fact being pressured to speak by Simon Butler, who was acting informally as an interpreter during the first recorded interview. When ruling the interviews inadmissible, Justice Hall commented that it is unlikely that the admissions of the accused would have been made at all if the interview had been properly conducted. All the indications are that if the accused had been treated as a suspect from the outset and had his rights explained to him through a qualified interpreter, he would have exercised his right to silence. And also, there is a significant possibility that answers given by the accused are unreliable because he did not understand what he was being asked, could not communicate his own thoughts adequately in English, or gave false answers in order to appear agreeable. This meant that the initial charge of murder was downgraded to manslaughter, and on the advice of the Aboriginal Legal Service, Gibson pled guilty to the lesser charge. A subsequent police review of Gibson's investigation and conviction has also cast doubt on Gibson's guilt and is the grounds for a fresh appeal against his manslaughter conviction. In fact, he's since been exonerated. The issues in the Gibson case would lead Western Australia's Chief Justice Wayne Martin, who's been very active in the language and the law area, to state that this was not an isolated event, but symptomatic of recurring systemic failures to cater for the language needs of vulnerable Aboriginal suspects. According to Martin, we have reason to believe that there are a number of those cases that are occurring regularly in Western Australia because we simply lack the capacity to identify the people who need the interpreters or to provide the interpreters when they are required. I'm aware that at least one member of our organisation, the International Association of Forensic Linguists, did give expert opinions in this case, and very recently the conviction was overturned altogether. So this case actually had some good news for the field, in that an expert forensic linguist was sought eventually and the wrongly accused person was exonerated. But there's also so much bad news. And the worst of it is that it is all so recent, after so much has already been done to stop exactly this kind of thing from happening. There are protocols and procedures, and there have been conferences and workshops and training. But in the end, the failure was, in my opinion, down to a basic lack of knowledge about how language works. The police officers knew that they might need an interpreter. It was discussed, and there is a record of that decision-making process. But what did they base their decision on? They made an assessment of Gibson's English language proficiency based on some casual conversation in the station. Wait, back up a moment. They made an assessment of Gibson's English language proficiency. Based on what training? Based on what knowledge about language testing and language acquisition? The fact that these officers felt that they could even offer an assessment, let alone that the assessment was based on a largely irrelevant and unrepresentative language sample, is the very issue that concerns me here. Despite knowing that there might be a requirement for an interpreter, the officers were ignorant of the underlying knowledge of language that might be required to assess language proficiency. To me, this is not a failure of protocols so much as it is a failure of education. People don't know what they don't know about language. Linguists know, because we're educated about how language works, that language testing requires specialised knowledge, and there are scientifically validated methods for assessing language proficiency, with limitations and margins for error. But most people, including most police officers, probably don't know this, at least to the extent that it applies to their work. And yes, I think this is a problem that is particularly acute for linguistics and linguistic fields of knowledge, but I'll return to this after we've gathered some more evidence. My next example is not a single legal case, but rather an example of a linguistic problem that I identified in the Refugee Review Tribunal in hearings in Australia. With this case, I'll demonstrate how linguistic knowledge reveals that an otherwise innocuous habit of tribunal decision-makers called members can have potentially catastrophic results for vulnerable asylum seekers. In this case study, I wish to acknowledge the input from another of my talented PhD candidates, Jessica Feindling. Jessica and I co-wrote the published paper from which parts of the following case analysis is drawn. The RRT was established in 1993 in order to provide an independent review of decisions made by the Department of Immigration and Border Protection, as it was then called, about an asylum seeker's application for protection. And it's structured in a less formal manner than other areas of justice. So the hearings themselves do not follow a strictly structured procedure, and they're non-adversarial by nature. So the members generally start the hearing with a preamble. And the preamble to the hearing is a process of explanation to the applicant and to any other participants to explain how the hearing will proceed and the roles to be played by those present. This is partially scripted in order to comply with relevant laws, but there are specific features of an RRT hearing preamble that are open to members' interpretation and can influence the subsequent interaction. During a research consultation involving observations of hearings, I noticed that during the preamble, members sometimes referred to a large quantity of information at their disposal, and some would gesture towards a very tall stack of files on the bench. However, when they did this, they would say something like, I'm familiar with the contents of your file, and they were unclear about whether they had a detailed knowledge of the contents of the files or a mere familiarity with the key points covered therein. I found that this simple and very understandable gesture can have serious ramifications for the applicant. Rules of conversation derived through the study of pragmatics have clear implications for the features of the RRT hearing preamble I've described. The Gricean maxim of quantity might apply to restrict what is allowable to new information. Known information is usually regarded as extraneous in conversation. We avoid telling people things they already know. However, being unsure of how much information is known to the member already, but being assured that something is known, perhaps everything in the case files, applicants will find it almost impossible to know how much detail to provide in their responses to questions. As the hearing progresses and the member asks various questions about the case, it is very difficult for the applicant to assess what the member already knows. When the applicant is unclear about what the member knows, it then becomes problematic for them to try to frame their response as new information. This is a highly specific and technical piece of knowledge about how language works, but it can have dramatic implications in an RRT hearing. In a review tribunal, there is not the opportunity to review every aspect of the case or to start again with an entirely fresh narrative from the applicant. The cases rely on the applicant to provide additional evidence to support their claim in relation to specific points that the Department of Immigration has found unsatisfactory. Therefore, their capacity to provide additional evidence to that already before the member means they must successfully navigate the known and unknown information, and all this is usually mediated through an interpreter as well. This sort of finding is fairly typical of research in our field. In fact, I could include almost every paper presented at the recent Forensic Linguistics Biennial Conference as a case study to support my argument. Highly specific knowledge of how language works is critical to understanding when a language problem has occurred in the justice system, as well as how to fix it. But while most of the papers at that conference were focused on the second part, the fixing of the problem, I'm more concerned at present with how the problems are identified in the first place. In case after case, it is only the chance intervention of a handy linguist with an interest in the law or justice processes that has pointed out that there actually is a problem. In fact, let me take my next example from the program of that conference. My friend and colleague Helen Fraser has been doing excellent work on forensic transcription and the problem of letting non-linguists interpret unclear recordings of speech and prepare transcriptions for court. In these cases, a covert recording, a bug in the old spy movies, has recorded a conversation that becomes part of the evidence against the accused. Think about drug trials, for example. If the speech can barely be heard or understood, as is often the case, it's very unclear, poor quality recordings, the courts will allow the police officer in the case to provide an interpretation of what was said. Here, the courts are labouring under the misapprehension that just because a person listens to a recording many times, they will have some specialised knowledge that allows them to hear words that no one else can hear. To make matters worse, the judge and or jury will usually be provided with a transcript of what the police officer thinks he or she can hear. And then guess what? They can all magically hear the same words, where previously it was just noise. Priming, anyone? Helen will excuse me the brevity of my treatment of her excellent work, because I know that those of you who are interested will want to explore the issues themselves through her wonderfully fun comprehension tests and experiments available online. In short, I believe that Helen has identified another example of where the justice system encounters a Rumsfeldian intelligence failure. They don't know what they don't know. In this case, they don't know what they don't know about phonetics, acoustics, and how we hear and interpret speech. I'm very pleased to see that Helen is working hard to address this failure, but it is a failure that more of us need to acknowledge. My doctoral candidate, Dave Gilbert, examined the breakdown of the evidence chain that occurred when Australian police used community interpreters to listen to Vietnamese language telephone intercepts or covert listening device live streams and transcribe what they heard in Vietnamese directly into English. There are just so many misconceptions about how language works in there that I can't even begin to list them. Suffice to say, the cases did not end well for anyone, but probably least of all for wrongly convicted Vietnamese defendants accused of drug smuggling. And to prove that the problems are current and broad-ranging in scope, just a few weeks ago, and it's come up again even more recently, I heard the international expert on English language testing and one of the authors of the IELTS test, the excellent Professor Tim McNamara at that university up the road, patiently trying to explain in a radio interview that setting a required IELTS score for migrants wanting to come to Australia was not an appropriate response to concerns about their fitness for life in Australia. The notion that there might be a fundamental difference between the language required for education, which is what an IELTS is testing, and the language required for anything and everything else in life was apparently not one that anyone in the present government of Australia had thought about. Mind you, this is a government that still thinks a suitable response to terrorism is to lock up asylum seekers in offshore jails, so the bar's not set very high there. My final example I will draw from my own area of interest, police interviewing. Specifically, I'm going to provide an instructive example from the wonderful and terrifying world of credibility assessment. Many years ago, I came across a training company that delivered courses in lie detection for law enforcement officers. At the time, I wrote a critical discourse analysis paper for a departmental linguistics journal about how this method is marketed to police. Now, it's worth understanding something about the American method of police interviewing here, because it provides an explanation for why lie detection courses are so popular in the USA and Canada, but less so in the UK, New Zealand and Australia. In North America, the standard for police interviewing protocols is known as the Reid method. It relies on 3 stages. The first stage is an assessment of the available physical or documentary evidence. And secondly, there's a non-accusatory interview with any persons of interest who are identified in the first stage. So far, so good. But it's the third stage that's problematic. The 9-step interrogation technique is not only highly coercive, but it involves interrogation methods that would not be legal in many countries. Even more concerning, though, it's so traumatising and effective in producing a confession that good police officers need to be very cautious about applying it unless they are confident that they have the right person. I'm sure you can see how troubling this is on its own. And it leads to other problems because, of course, for an officer to be sure that they want to proceed with this kind of interrogation, they want to start using all kinds of credibility assessment tools in the second phase to figure out if their person of interest is credible or if they might be being deceitful. It's entirely predictable then that officers under such pressure will reach for any tools that purport to help them in making this difficult decision. And that's where the Laboratory for Scientific Interrogation has found its market. The main product sold by LSI is known as SCAN, Scientific Content Analysis. Some of you might be familiar with other forms of content analysis. There's criteria-based content analysis, or CBCA, and statement validity analysis, and no doubt others that follow the same principles. So what are these principles? Well, the idea is that there are markers in language that are positively correlated with lying. Just as there are behavioural cues to deceit, there are linguistic cues to deceit, right? Actually, there aren't any behavioural cues to deceit. And polygraph tests don't work. Never mind, these language tests are different. They use linguistics, and we all know, well, actually, we don't know anything about linguistics, but SCAN sounds really super scientific, doesn't it? I mean, the clue's in the name, right? Scientific content analysis. So what are some of the language analysis skills that SCAN will teach you? As described in their website, you can look at this, SCAN teaches you that when someone switches from the past tense to the present tense, they are demonstrating a lack of commitment. Because we all know that nothing says commitment like I did. SCAN also teaches vital clues like the use of anaphora, that's replacing a full noun with a particle like it, which also means you're lying and that you don't care about something. I could go on, and if you want a good chuckle, I suggest you go to the website and see for yourself. It's hilarious, right? Except people have been convicted on the basis of this technique. I have an article written in 1996 by FBI agent Susan Adams, which reads as follows. Susan Smith stood outside her burgundy sedan and released the parking brake. The car plunged down the ramp into South Carolina's Long Lake with her sons, Michael, 3, and Alexander, 14 months, strapped into their car seats. To cover her actions, Susan told police that the boys were abducted at gunpoint, launching a nationwide search for the victims and their abductor. During the investigation, Susan tearfully told reporters, "My children wanted me, they needed me, and now I can't help them." Yet the boy's father, David, who believed Susan's story, tried to reassure her by saying, "They're okay, they're going to be home soon." Police subsequently arrested Susan for the murder of her children. She was tried and convicted and is currently serving a life sentence in a South Carolina correctional institution. Many investigators use a technique called statement analysis to discern the truth in statements like the ones given by Susan and David Smith. In statement analysis, investigators examine words independent of case facts to detect deception. They also remain alert for information omitted and question why the suspect may have done so. Investigators then analyse the clues unintentionally provided by a suspect and use this insight during the subsequent interview. In the case of Susan Smith, by analysing the statements made by the victim's parents, one could conclude that the father believed the boys were alive and the mother knew the children were dead. The key to this deduction, in case you can't tell from my tone of voice, I'm still quoting here, lies in simple English grammar. Specifically, verb tense. The father referred to the children in the present tense. The mother used the past tense. Of all times when the abducted children really would need their mother, she speaks of them in the past tense, e.g., they needed me. The children could no longer want or need her because they were no longer alive. If this sends a chill down your spine, then rest assured, actually no, don't rest assured, this method is still alive and well and being taught in the USA, Canada, Mexico, Israel, and despite not using the Reed method of interviewing, the UK, Australia and Belgium. In fact, here's a list of the 2017 training dates in the USA. I wrote about the scan technique back in the late 90s and never even bothered addressing the underlying lack of validity of the method because I thought it was so obvious that it didn't need stating. To me, what was interesting was why police would be drawn to something so clearly bogus. Nearly 2 decades later, I am finally realising that I made a grossly false assumption myself, that ordinary people would be able to spot the difference between real scientific analysis of language and this joke of a technique. In fact, my error in judgment was even more basic than that. I had assumed that ordinary people would know that there was such a thing as linguistics. Okay, so I'm a slow learner, but I've got there in the end, and I'm determined to start addressing this problem. Let me talk about how this might be done. Within the forensic linguistics community, we need to set professional conduct standards. 2 years ago, the then outgoing president of the International Association of Forensic Linguists, Professor Ed Finnegan, gave a stirring and well-documented address to delegates about the importance of setting professional standards in forensic linguistics. I'm not going to repeat his words. I lack his eloquence and gravitas, for one. But I agree that this is fundamental to addressing the lack of recognition of our expertise as forensic linguists. I'll focus instead on 2 other aspects of the problem, education and profile raising. With regards to education, it should by now be clear that I believe many cases of wrongful conviction, questionable decision-making and unlawful procedures could be avoided if ordinary people understood the basic principles of linguistics. If forensic linguistics had a similar status in the criminal justice system as forensic psychology, for instance. Psychology has long been a staple elective in schools. And although psychologists might argue that pop psychology on daytime talk shows does more harm than good, at least people have heard of the discipline and might be inclined to consult an expert if something that appears to be a psychological problem occurs in the course of an investigation or a court case. And when new cognitive or behavioural issues are identified, there is a recognised pathway for expanding the necessary education and procedures for justice professionals. Thus, we now have family psychologists to assist in child custody cases and intermediaries for people with cognitive impairment being interviewed by police. And for those who know the case, yes, it's true that Gene Gibson was suffering from a cognitive impairment that was also not picked up or attended to by police, but this was largely masked by him being prevented from communicating in his first language. An Australian education framework that sees linguistics as an essential tool for the teaching and learning of English as a first language would be a tremendously significant step towards justice for many people linguistically disadvantaged by the legal system. Linguistics, disguised under the course name English language, is being taught as a poor second cousin to the standard VCE English course in Victoria, but not, as far as I know, in any other states. I understand that there is a similar program of study for British students taking their A-levels. But in Australia, at least, there is a strong cultural resistance to the teaching of linguistics by an education system that glorifies literature as the pinnacle of English studies. If I were being unkind, I might suggest that the authors of English curricula are reluctant to introduce linguistics because it will force them to confront the shortcomings of their own knowledge of English syntax and semantics. In any case, linguistics is regarded with disdain as the formulaic or simplistic analysis of language that lacks both the creative heritage of literary criticism and the commercial appeal of media and communication studies. This is hardly a basis for a system of first language education. Artists must develop creativity and knowledge of the cultural heritage in their chosen form of expression, but that is not seen as a prohibition on them learning how the technology of their art actually works. If a potter can't learn how the wheel turns, then no pot will get thrown, artistically or otherwise. Students who are taught the basic concepts of linguistics, the core forms of analysis that are presently the topics of any first-year linguistics unit, might at least have a fighting chance of recognising a linguistic barrier in the justice system when they see one. The police officers intending to interview Gene Gibson might have considered that his English language proficiency was not something that they were qualified to assess. Members in the RRT, upon repeatedly struggling to elicit relevant and detailed information from highly motivated but frustratingly confused applicants, might have seen that the problem was one of pragmatics, or at least language in some form. They might then have reached out to a linguist years ago instead of engaging me almost by accident for some professional development training. Court interpreters might never have to deal with judges who insist on everything being just translated word for word, because they remember that each language is a complex system of meaning and equivalence between them is never perfect. And the Attorney General's Department would not be using Scan to vet their security staff because they would know enough about how language works to know that changes in tense are unlikely to be a consistent marker of deception. And it might be worth asking a linguist if this Scan thing really works, the same way that if they were going to install a new bathroom, they might check with, say, a qualified plumber. So a change in English language education policy would be high on my list of priorities for improving language-related justice outcomes in Australia, but it's a long-term strategy. So in the meantime, we can probably only rely on professional development training, which is conditional on the profession actually knowing that they need to know something. We seem to be back to where we started, don't we, in old Rumsfeld? Okay, but before we start gnashing our teeth and pulling our hair, or as described by Brown and Levinson's politeness theory, committing on-record face-threatening acts towards authority figures and English teachers, I do have some suggestions. So, for linguists, I suggest that you use any position of authority you have to offer a sound linguistic interpretation of a relevant current event or local issue. This certainly doesn't mean a flash analysis or hastily drawn conclusion, just a statement that points out that there is a linguistic problem at play. Tim McNamara's commentary on the IELTS test is a good example. We can also write pieces for The Conversation and other media to explain the relevance of a linguistic perspective to current affairs. I found myself doing a live radio interview about the discourse patterns in the famous Trump-Turnbull phone call, offering a critical analysis of language and power on an afternoon drive program in South Australia, if you can believe it. Now a whole bunch of South Australians know that linguistics is a thing. And last but not least, there's something for the creative types out there. Forensic Linguistics Crime Writing Competition. The Melbourne chapter of Sisters in Crime run an annual crime fiction short story writing competition. I've proposed to the convener that next year the IAFL will sponsor a prize for the best story featuring an authentic forensic linguistics related plot or character, and we encourage any entrants to consult a member of the IAFL for advice or inspiration. So off you go. You could be the next Karen Slaughter, but, you know, with linguistics. Now, to get you all started in this brand new world of linguistic awareness, I've made a list of things that might be useful, hopefully. So, start listening to language, really listening. Notice your language attitudes. We can't all be linguists, that would be a really dysfunctional world. But we can certainly be aware of how we discriminate on the basis of language. Language is variable, but systematic. Who we use versing on the weekend is legitimate and carries meaning just as well as its standard alternative, arguably more efficiently. Social context is the most important factor in deciding how appropriate the non-standard usage is. If you don't have a reliable, evidence-based test for assessing someone's proficiency in English, and there's a possibility that their English proficiency might not be adequate for clear communication in your professional setting, you need an interpreter. And by the way, you need an interpreter, not they need an interpreter, or an interpreter is required. Also, interpreters work with spoken language, translators work with written language. Just remember that one, because I've heard a number of professionals say, no, I don't want an interpreter, I want their speech to be translated word for word, as though what an interpreter does is somehow make something up. And also, there's no such thing as translating word for word in any way that will make any sense to the listener. Languages have different structures. Look, if you say, il n'est pas possible, and you translated that word for word, it would be something like, it not is not possible. And that's a really simple example from a language that's really similar to English. You can't tell for sure when someone's lying. That's it. You just can't. Get over it. Transcribing speech from a recording into another language is not something that interpreters or translators are trained to do proficiently in the current curriculum. You'll have to borrow a cryptologic linguist from the army if you need that done. And finally, if it's a language problem, don't ask a psychologist. Don't ask a speechwriter. Don't ask an historian or a novelist or a mediator or an English teacher or a film critic. Do yourself a favour. Ask a linguist. Now, before I initiate a pre-closing sequence, sorry, that's a joke for the discourse analysts, I want to promote the important work, there's 3 people after that, that's being done in Australia to address language challenges in legal decision-making. A group led by Diana Eads and Helen Fraser, who I mentioned before, ran a workshop at the Australian Linguistic Society conference last year and plans to run another one this year in December. In between, we met in Sydney to discuss strategies, and many of the issues and ideas I've mentioned here are being thrashed out by that group. I urge colleagues in law and criminology here today to stay in touch, and we'll be happy to share what we learn. Well, I hope that I've left you with some sense of optimism in what has otherwise been a rather grim summary of language expertise in the world of the law. It's also important to acknowledge the goodwill and ceaseless efforts of campaigners for justice, many of whom have come from within the ranks of judiciary and law. I hope that some of the emerging and aspiring researchers in the audience will rise to the challenge in coming years. So good luck, and may the illocutionary force be with you. Hey, come on, it's John Searle, Speech Act Theory, illocutionary force, illocutionary effect. See, now you see why you need linguistics, because the jokes are just great. Thank you. So, I'm happy to take any questions. I'm aware that there's a lot of professionals in the audience, so people who work in this field. There's also some linguists, and I've also got some people here tonight who have been really involved in forensic linguistics. Peter Gray, I'm looking at you right there. So any questions? We've got microphones somewhere. There's one. You've got one. She's way ahead of me. Thinking time? Would you like me to play Jonathan Richman again?
Hi there.
Hi.
Is that on? Hello? Is that on?
I think so.
Project my voice a bit. Yeah, okay. I'd just like perhaps to add that it's not only spoken languages. I'm a sign language interpreter.
Yep.
But I was just wondering, there's a long-term goal you're talking about reaching school education. Do you approach the police academy or the judiciary around educating those decision makers around the problem?
Yep. So myself, Diana Eads, Helen Fraser, Sandra Hale, so we're all people who work in this intersection of linguistics and the law, and I've given countless professional development sessions. Interestingly, I rarely get engaged by police in this country. I've given training to police all around the world, but in Australia there seems to be a reluctance to engage. However, we get there by stealth because I teach here in the Justice and Legal Studies program, and so I teach forensic interviewing and have some interaction with intercultural communication. About a third of our students taking the bachelor course in Justice and Criminology, they go to the police academy. So I'm not saying they make up a third of the entrance to the police academy, but they would make up a good number. So we're kind of getting there by stealth. Yeah. The research findings that are generated through my group certainly contribute to, to policing in some way, but how direct that is, I don't know. But I mean, that was my point, that unfortunately often requires the organisations to reach out. There's a structural problem with giving professional development to lawyers, and any lawyers in the room will know this, that you get CPD points for both giving and receiving. So if you give a lecture, you get professional development points that go towards your legal qualification or requalification, whatever it is, which means that there's a very large pool of presenters who are willing to do it for nothing, which means that they very rarely go outside of the legal profession when they're looking for presenters for their professional development sessions. And if you are from outside and you ask for payment, you'll often be rebuffed. So I have given professional development sessions, but I and many other linguists, I mean, there's a limit to how much we're willing to do for nothing. Anyone else? And it's all about language, but don't worry about how you speak.
Georgina, you mentioned earlier that there's a competition for authors.
Yes.
Are there any examples of linguists, forensic linguists, that have been well depicted that you can think of in popular culture and popular media?
I don't well depicted. So Diana Eads, who I mentioned earlier, Diana Eads has done a huge amount of work, for those of you who don't know, around Aboriginal language, in particular Aboriginal English, and interactions with the legal system, and has given evidence in a number of cases. And she herself was depicted. She didn't feature in the program, and I can't remember which. It was one of the popular crime programs. She didn't feature, but somebody representing her was depicted, but unfortunately was depicted as a very cranky and narrow-minded academic that wasn't really willing to engage with the justice system. Do you remember hearing Diana talk about that? She was really disappointed and a bit embarrassed. Yeah.
The opposite of Diana.
Yeah, exactly. Yeah.
Hi, I'm an interpreter. I just want to say something. You mentioned about in RRT the member says, "Oh, I know your case," right? But I have also seen in my practical life, many members also say to the client, "Oh, you can speak English, can't you? So just let's talk to you in English and use the interpreter when you need it," right?
Yeah. Use the interpreter when you need it, yeah.
Forcing the client to come out in English, speak in English, whatever command of the language you have.
Yeah.
And that could cause another level of implications because now the client has forcibly agreed.
Yeah.
Sort of, right?
Yeah. So
that's also a question that needs to be raised to that level when you're talking to the judiciary.
That's right. So a couple of things I'd mention here. One is just sitting behind you is Joe McFarlane. So Joe's actually, his PhD research that I mentioned earlier is actually looking at the engagement or the way in which lawyers engage interpreters or think about engaging interpreters when they're communicating with their clients, because there does seem to be a missing link there. We know that there are protocols and there's been at least some research into police use of interpreters and lots of work, particularly by Sandra Hale, on courtroom interpreting, but the interaction between lawyers and their clients, I think, has been overlooked, probably because it's seen that the lawyers are on the client's side, they're on the defendant's side, so you'd imagine that they would be highly motivated to get an interpreter, but I think what we're finding, if I'm not right, is that, again, it's just this ignorance. And the cases you describe, yeah, exactly, it's that, let's just get on with it, If you haven't seen it already, the Northern Territory Supreme Court produced a video of what they call a reverse role play at a conference in 2015. The conference was called Language and the Law. So if you Google Language and the Law, Northern Territory Supreme Court, 2015, reverse role play. Now, I think NAJA actually mounted the video so you can watch it. That's the Northern Australia Aboriginal Justice Agency, I think that's right. So it's wonderful. It's a fully enacted courtroom where all the parts, all the roles in the courtroom that would ordinarily be played by native English speakers are played by Aboriginal speakers using the local language. And then the defendant is played by... Yes, Dean Mildren, Justice Mildren, who himself has been very active in the area and is the willing victim in this scenario. And it's just wonderful. And to see so starkly how it makes such a difference when, an interpreter is made available, and the kinds of assumptions that people make about language. Somehow it's much easier to see when you see it in another language. Questions?
Well, firstly, thank you, Georgina. As a fellow linguist, I really appreciate the whole presentation on the importance of linguistics and particularly forensic linguistics. I wonder if you could just talk a little bit more about English language or linguistics in secondary schools.
Sure.
Because as well as it being really important for this, obviously if more students know more about the English language, it will have all sorts of other benefits as well.
Yeah.
So just what is the situation at the moment and how do we get it fixed in the curriculum?
So my friend and colleague Kate Burridge, who many of you might know from the radio, some of you will know professionally and as a colleague, and she's a professor of linguistics at Monash University, very prominent speaking about language. Her area is Australian English and the history of English. So she used to have a radio program or was a regular guest. She co-authored a curriculum for an alternative stream of English. So there's English, and what we would call normal English, the standard VCE subject that all Year 12 students are required to take. And then there are 3 other types of English that Year 12 students can take. So there's English literature, which has been around forever, and I took myself, in fact. There's English as a second language. I don't know if they still call it that, but English as an additional language. And that again, is also very well established. But then, yes, Kate co-authored the curriculum for the new entrant to the field, which is called English language. I would describe it as it's kind of loosely sociolinguistics. It's got that language in society feel to it, but it doesn't teach linguistics in a systematic way. It's still being fairly tentative about the way it approaches linguistics as a field of study, which is really disappointing because if you look at any other discipline, it's taught at the school level in a way that is ready to lead on to the university or the tertiary level study. So if you do chemistry, you know, you don't learn some, I don't know, short version of the periodic table or something. Like it, so the English language is a bit disappointing in that way. I think any of you who have done it or looked at it would recognise, and have also done linguistics, would recognise that it's not quite there. I rather suspect it has the same relationship with linguistics as legal studies might have to studying law. I'm looking at my father here because he's a lawyer, and I think there's that, it's like, oh, well, it's sort of an introduction, but it doesn't lead clearly onto linguistics, which is a shame because it appeals much more, according to the surveys that have been done, it has greater appeal to boys. So the systematic study of language as opposed to the creative study of language appeals more to boys. And it also appeals to students who are taking EAL as well, English Additional Language. Below the level of Year 12, it's a very mixed bag. In fact, it's a pretty much empty bag at the moment. I gave a presentation at a conference for English teachers, and there was lots of interest in the room, in the English language room, in how we might introduce a kind of, if you want, English language, linguistics, at lower grade levels. Now, I actually did a fantastic workshop with a group of grade 5 and 6 students where we analysed a crime using language. So it was a threatening letter, and not a real one. It's okay, I didn't traumatise the children. It was literally who stole the cookies from the cookie jar. That was the original setup, and then we had a note that they analysed. And that worked really well. I repeated the workshop with Year 7 SEAL students, so these are slightly more advanced Year 7 students. In that we included a grammatical analysis it was a ransom note that one of their teachers had been held hostage. We included a statistical analysis, so it was a mixed English and maths class actually, and we looked at some other forms of language analysis, so some phonetics and things like that. So, and they loved it, you know, they got really engaged with it. There's lots that could be done there with all year levels. This is not something that needs to be held off. I understand that in Year 10, there are teachers who teach Year 10, particularly Year 10 SEAL students, who are looking for an advanced track on their English, and they at that point they can introduce elective, subjects within the English course, and so they're looking at forensic linguistics as something to put in there, because those are for students who are intending to go on to English language in VCE level. But there's nothing systematic happening. The publishers of the English language curriculum, Boo Books, are very engaged in the field and very interested to get something going. So I think there'd be, if more linguists were interested in it, you know, and this is the problem we're up against. I mean, how many, I'm not going to embarrass people, but honestly, how many of you are a linguist or know a linguist? Almost no one, right? It's a very, very small field. Kerry and I work in this area. There is no linguistics at RMIT. We're leading the rebellion from within, but it's a tough call. It's not a well-known field. There's not a lot of people doing linguistics, and we've got a lot of ground to cover. You know, most of the linguists are out there swatting away the flies and the mosquitoes, or wading through swamps holding their precious recording equipment above their heads, recording languages that are about to become extinct. That's the job of a lot of linguists. That's what a lot of linguists are out there doing. And then you've got all the phoneticians and the syntacticians and the semanticists and the pragmatists and all of these people. Pragmatics doesn't mean what you think it means, by the way. And they're not at all practical. Just talk to Keith Allen for 5 minutes. But my point is, we're stretched really thin. And then within that, you've got this tiny group of people who happen to have some interest in the law, who happen to understand the legal system as well as being a linguist. And frankly, I could probably sit them around my dinner table, and I know all of them. It's a really difficult issue. Yeah.
I'm just wondering some of your research. I'm just wondering if some of your research includes interpreters, because there's a lot of issues for us as interpreters in the legal system, and I think we individually need to be able to articulate the differences between the language. Do you do any research with interpreters? Or?
So, could my interpreting students stand up? So my PhDs who are doing work in language interpreting, there's Chehan there who's looking at, thanks Jan, modes of interpreting. Miranda, I saw you hiding there somewhere up there. Yes, wrote a book and recently completed her thesis. Yay! Looking at the police interviewing methods and how that gets impacted by interpreters. So yes.
It's my favourite book, and very sad that Sadat is no longer with us.
Yeah. So absolutely, and it's just there's not many of us, and our field is not well recognised. So I mean, how many proposals from linguists have been funded by the ARC recently? You know, I don't know, none. And that will probably be for historical linguistics or, you know, endangered languages, which is fine. It's just that there's not much money to go around, so the funding is difficult, and the police don't really like to engage with academics very much. So that's quite a tough gig. Some do. Not individual police officers are great, like they're really keen, and I have a police officer who comes and co-teaches my forensic interviewing course with me, and he's wonderful. But institutionally, there's a real problem there. Yeah. Anyone else? Peter?
I have one thing that troubles me when it comes to educating the public about what is linguistics and
just
what
one.
It means. Well, just one that particularly troubles me. And I know Kate Burridge and I admire her tremendously, and I enjoyed listening to her sessions on the radio, but I wonder whether they're not counterproductive. Oh, linguists are those people who tell us cute things about the origins of words. Yeah. Well, they are, but there's so much more, and the public, I suspect, tends to discount the field to that, to what they hear on the radio, right, and not to expect it to accomplish more. Yeah. Am I right in that or not?
I'd hate to think that any publicity about language analysis is undermining, but I take your point, and I think it's a fine line. On the one hand, it's easier to engage with an audience about things that they already understand, and word origins is something that everyone just loves. You know, everyone loves to talk about, you know, where this word came from or that word came from, or what is the right way of pronouncing something. Never ask a linguist that question. There is no right and wrong. We hope that that's kind of the hook that gets people in, but I think you're right that just the way that psychologists complain about pop psychology, that then becomes the be-all and end-all of what people understand the field to be. Again, if people had this introduced to them in their schooling, if this was just a normal thing that people were introduced to theories of, you know, syntax or theories of semantics right from an early age, they might not understand all of it. I didn't really understand my physics that well, but at least I knew physics was a thing, you know.
Yeah. There is a science of language.
Yeah, exactly. Yeah, that's probably the most important. That's what we need on the T-shirt.
There is a science of language, and there is an elective that can be dropped when you hit year 11, yeah?
Hi. I'm the Polish language interpreter, and just agreeing with the previous person, would it be possible for linguists to be more involved with interpreters training? Because we have not only to deal with police interpreting, but also when it comes to mental interpreting. So quite often professionals will ask us about what do we think about it, about the choice of words the patient uses, and obviously we're not trained for it. And plus, we are trained interpreters.
So that goes to a point that was raised with me before we started tonight privately about how do you respond if you're an interpreter and you're called to give evidence about your interpretation, about your rendering. How do you respond to questions about what was the decision making that you went through? Why did you give that version? Because we all interpreters understand, linguists understand, there's no one way to interpret from one language to another. There's always going to be variation. So then it comes down to why that way? Why did you... And that can mean that your professionalism can be under question. And what you're saying is similar to what my colleague was saying to me earlier, which is there's not really at the moment training for interpreters about how to understand the decisions that they're making. Now, I would imagine, Miranda, where is she, that in the coursework that we provide here at RMIT, that there's quite a high level of engagement with linguistic theory as well as interpreting and translating theory. But I'm conscious that there's a limit to how much you can actually teach. It's enough to learn about linguistics, let alone, interpreting and translating has its own whole area of theory. Trying to include comprehensive linguistic training in that is difficult. But I think getting interpreters and translators and linguists to work together is probably the answer. And that's why I think Miranda and I have had a very fruitful engagement through her PhD, because we're coming at it from a different angle. It's very much about the interpreting and Miranda's understanding of the interpreting was the key to the research. But I think it was important to have a linguistic perspective through the supervision. Did you want to add to that, Miranda?
Thank you, Georgina. Thank you, Andrew, for your question. I think what Georgina, you were saying was absolutely right in the sense that interpreting and translating training so far, at least at RMIT or across the country, probably we emphasize much more on interpreting theories, equivalence, on that front rather than linguistics. So indeed, it really is probably a future professionalization direction we have to get into, and like what our collaboration has led to so far, it is something that we have to focus in the future.
Yeah. Thanks, Miranda. I mean, it kind of surprises me in a way that judges, particularly judges for some reason, seem to struggle so much with this notion that what an interpreter does is not translate word for word. Because translation, literary translation, I would have thought, is a pretty ordinary thing that most people would understand. That if you get, a copy of Crime and Punishment that's been translated from Russian, you understand that there are different translations of that book, right? Like, everyone gets that the translator's role in translating a great work of fiction or non-fiction, whatever, is key. Like, in other words, there's a role there. It's not just some automatic machine-like thing, because that would mean that all possible translations of Crime and Punishment would be identical, but they're not, and we understand they're not. Sometimes I really wonder why that's such a hard concept, and yet people really have this idea that it is possible to translate word for word, that, when an interpreter interprets in court, that it will be possible for them to render in the target language exactly what was said in the source language, and it would never differ. That's just a bizarre assumption.
Imagine Crime and Punishment with English words in Russian syntax.
Yeah, that would be fun, wouldn't it? Now, there's a challenge.
Maybe they don't mean word for word literally. Like, maybe that's a turn of phrase, and what they mean is interpret everything, don't leave anything out.
Yeah, maybe.
Rather than, word for word.
Yeah.
Maybe.
Case
Give
marking.
them the benefit of the doubt.
You know what I mean? Like, there's a misunderstanding about the grammar and, things like case marking or tone that don't exist in English, or not to any meaningful extent. And how do you translate that? Yeah. Anyway, sorry. Dave?
Thank you, Georgina. In relation to your question, why do legal practitioners look for translations word for word? I think that if you look at any act of legislation, there is always a glossary of what every important word actually means. So when you're asking the courtroom not to literally translate words, it sort of goes against the grain of how legal practitioners work. So if it doesn't make sense at the word level or in a provision, then they'll look to the wider aspect of the Act and beyond it for the purpose of the Act, and that makes a lot of sense to legal practitioners. So when we're talking about interpreters who enter the field or enter a courtroom where they're under pressure, God knows if the trial is commenced on time, all we want to know is what the witness is saying or what the accused is saying. I don't know if they actually mean to put the interpreter in a difficult situation. I think it's just that both fields come from different perspectives by default.
Yeah.
So if I could offer that,
sure.
Perhaps Peter could elaborate on that as a formal judicial officer, if I could say that, because the way I see it, that's how judicial officers work. They're looking at the letter of the law.
Yeah.
As a translator myself, I know all the problems in relation to doing that from an interpreter and translation perspective.
So, I mean, what that brings to mind for me is something that I should have included here and I didn't, but you can look it up. There's a plain English legal dictionary that was developed by... Who developed the plain English legal dictionary? I want to say that was the NAJA again, but I can't remember. Do you remember, Joe? Aboriginal Interpreting Service, and if you look it up, it's great. So what it does is it provides a plain English description of what the legal terms in the Australian legal system mean. And, you know, for each term there might be a whole paragraph to try and describe what that term means. And right there you can see, this is where a lot of the problem lies. So, as you can imagine, most Aboriginal languages do not have words for a lot of the concepts in the Australian legal system. So there is no equivalent term. I imagine that a lot of those Aboriginal languages might borrow an English term, otherwise they might use a descriptor to get at that meaning. And the plain English legal dictionary provides these standardised descriptions. So they were workshopped by a lot of people who had a huge amount of knowledge, both of the languages but also the legal system, and linguists. And they're what might be described as a front translation, for people who know what that means. And they were used to then translate into an Aboriginal language. So they're a description in English using plain English that can actually be translated into an Aboriginal language. Now, that could also apply, I do some work in Mozambique, that could also apply to Mozambican African languages. So same problem there, that those African languages don't have words in them for a lot of the, in Mozambique, Portuguese language terms. So a plain Portuguese legal dictionary would be a really useful thing to have, for the same reason you create a front translation that can then work in a language that doesn't have those words. So that's one way to address the problem, but it points to how complex the problem is. And as you say, Dave, in the legal system, that level of ambiguity isn't comfortable at all. I think it gives lawyers a lot of indigestion, you know, that feeling that it's not, there just isn't an equivalent, and we're going to have to use a description. So I know in the Northern Territory the police have a system where they have the caution, the police caution, you know, you don't have to say anything unless you wish to do so, all of that. They have that recorded in Aboriginal languages, right? But they had to go through that system of making it into a plain version first, then translating that into an Aboriginal language with all the appropriate expertise, and then recording it. And they carry it around on their iPads. And you know, if you want to give an iPad to a child and you're worried they'll break it, just buy whatever that is that the Northern Territory Police put on their iPads, because, man, these things look bomb-proof. Anyway, they carry around, because you can imagine the kind of territory they're going through. They carry around these iPads in these kind of brick-like cases, and when they're interviewing a suspect, they first of all work out what language it is. They have an interpreter present, but instead of getting the interpreter to have to manage all that difficult legal language, they play the translation, and it's rendered in the Aboriginal language in the audio, and the text is provided in English of what the person is hearing in their own language, so the police officer can follow it. And I said, so how does that run in the police interview? It must take a while. And he said, oh, look, it's fantastic. You know, we get through, it takes about 7 to 9 minutes to get through the caution. So that's a real improvement, because it used to take us about 40. I'm like, whoa, okay. But yeah, it would take about 40 minutes just to do that bit that you do not have to say anything unless you wish to do so, but anything you do say may be given in evidence. That would take 40 minutes because of this problem of equivalence and
Except
concept.
that hearing loss is a huge problem in that community.
Yes, indeed. So, and it's only used for the caution.
So have they really heard it?
Yeah. So one of the reasons why they provide the English language translation is so that if there's any point at which the person, the suspect, doesn't understand, and remember they have an interpreter there as well, so if they indicate they don't understand, at least they know precisely which bit of it they didn't understand. But yeah, that's a really good point as well. And I know there are a lot of people working in the sign language in the Aboriginal communities. Yeah. Yes.
Hi. Relating to your question before, have you seen Arrival, and did you like it?
No, I just I couldn't. I feared it would be the same experience for me as when I heard about the other one was. Because I do a lot of stuff in lie detection, and there was a thing about a detective who could just sense when someone was lying magically, and was supposedly based on a lot of research. But anyway, no. But I do know a lot of linguists who saw it and liked it.
Yeah,
so.
There's just one scene where they go, "Can't you just do this? Can't you just ask them?" And this linguist explains, "Well, you have to understand what a question is, what this is, what this is." And everyone went, "Oh." It's very satisfying. Just watch it for that bit.
Yeah. Okay, any more questions, or we might draw it to a close?
I just respond to David's invitation for me to say something more. I think the issue of courts and interpreters is a very multi-layered thing. I mean, at its base level, it's about time and expense. If you use interpreters, that part of the evidence is going to take twice as long because everything's got to be translated and translated, So you're doubling the length of that part of a trial, and you're thereby adding to the expense of the trial. And that's seen by everybody, the court, the lawyers, everybody else, to be a big problem. Interpreter fees have to be paid somewhere along the line, so that's even more expense. So the kind of pressure is to say, oh, well, look, you can have a conversation about the football, so she'll be right. Let's get on with it. And I know, and now, because I stumbled across forensic linguistics in 2003, that's just not on. But many, many lawyers don't. They're impatient of interpreters. Going way back to my early days as a junior barrister, I also think there was a fair amount of distrust around. This person comes from the same ethnic community as the witness or as the accused and will be helping out the accused. And the whole problem of talking about equivalence is not seen as a problem of the kind that we're talking about here. It's seen as a problem of the kind that, God, the interpreter's got choices. Is the interpreter choosing to render this in the most helpful way to this person rather than in the most harmful way? And that's a real issue that we have to confront in relation to education. So those are the kind of the base level instinct things that you've got to get over. We have, I think, begun to recognise that things like, you know, literal translation, word-for-word translation just isn't impossible. I remember reading an article that the great Michael Kirby published years ago, in which he referred to a case in which the magistrate, having found someone guilty, was considering sentencing, and an issue of the health of the defendant arose, and the magistrate asked, "How do you feel?" And the interpreter translated the question, translated the answer back as, "I am the God of gods." So the magistrate promptly ordered a psychiatric assessment of this person. It turned out that "I am the God of gods" in whatever language the person spoke was an idiomatic expression, roughly the equivalent of "I'm on top of the world." Now, if you asked someone, how do you feel, and they said, "I'm on top of the world," you wouldn't be sending them for a psychiatric assessment. But, you know, if you get that literal translation, and not the literal translation is "I'm the God of gods," it means "I'm on top of the world," that would have solved the problem. Yeah. So I think there's a bit of understanding of that kind of issue, that idiom just doesn't translate word for word. Yeah. I'm not sure that it goes terribly much deeper than that into all the issues of equivalence. Yeah. And as you say, into grammatical things and semantic issues and all of those things. It's a very complex picture. Yeah. But we do need more education. Sandra Hale gets to talk to the new judges in their introductory course, something that they never had when I became a judge. But
and you and John Gibbons have been working on a unit.
Oh, John Gibbons and I teach a master's subject at Monash. They offered it in 2015 and not this year when it should have been offered, but I've got it back for next year. So I've had to fight. But lawyers are somehow very resistant to the notion that anyone can teach them anything about language. Yeah. And particularly that linguists might teach them anything about language.
Yes, I think they rather think they're linguists already.
Oh, they do.
Yes. All right. Well, thank you all for your participation. It always makes it more enjoyable, and let's keep talking.